Good morning and welcome to the Public Service Commission of South Carolina. It is 10 a.m. on January 4th, and we are here today for a hearing in docket number 2023-29-S. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. I note for the record that Vice Chair Powers is on leave and is not present. I'll recognize our staff counsel, Ms. Mosier, to read the docket, please.
Thank you, Madam Chair. Good morning, commissioners and parties. We are here today for the proceeding in docket number 2023-29-S, which is the application of JACABB Utilities, LLC, to establish sewer service area and rates and charges in certain portions of Pickens County, and request for approval of the sanitary sewerage asset purchase agreement with Cliffs Club Holdings, LLC at Keowee Springs. The proceeding has been scheduled for today, January 4th, 2024 at 10 a.m. I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Mosier. Let's take appearances from the parties. Who's representing the applicant, JACABB Utilities, LLC?
Madam Chair, I'm Scott Elliott. I represent the applicant in this matter.
Thank you, Mr. Elliott.
Pleasure to be here.
And who's representing the Office of Regulatory Staff?
Thank you, Madam Chair, members of the Commission. My name is Ben Muschin. With me today is Ms. Cassidy Murphy, and we're here today on behalf of ORS.
Thank you, Mr. Muschin. And Ms. Murphy, I think today is your first appearance here?
Yes.
Well, just want to say welcome. Thank you, ma'am.
Thank you, Madam Chair.
Preliminary matters. I think we have a couple to deal with before we begin. Is that correct? Mr. Elliott, you recognized?
Madam Chair, the parties have entered a settlement agreement in this matter, which resolves all issues. In light of that, and consistent with that, there are pending motions for confidentiality of certain documents. The parties have agreed to treat those documents as confidential and would request that the Commission do so in this case.
I think we have a letter from ORS designated certain portions of Mr. Hunnell's direct testimony as confidential. Is that correct? The first one. So we will hold those as confidential. And then I believe you had a motion for protective order with regard to attorney's fees. Is that correct?
That's correct. Yes, ma'am.
For purposes of this hearing, we will enter that as a confidential exhibit.
Thank you so much.
Anything else? Does that take care of all of this?
I think so. I mean, it's a relatively straightforward matter, and I think the settlement agreement speaks for itself, and I don't know that I see any purpose in reviewing it for y'all this morning.
Well, if there are no other preliminary matters.
No other preliminary matters. I wasn't sure if the Commission wanted to go ahead and make the settlement agreement as an exhibit, or we can wait and do that with Mr. Goldie, whatever the Commission's pleasure. And I have copies available if the Commission prefers.
Either way, who's going to enter it?
Let's go ahead and enter it by consent as hearing exhibit 1.
There's no objection, so this stipulation, it's captioned stipulation. I don't know the difference between a stipulation and a settlement agreement. If somebody could explain that to me someday, I'd appreciate it. But the document titled stipulation and filed yesterday?
Yes, ma'am.
I picked up the wrong stipulation.
Yes, ma'am. I think according to the document we filed, we identified it as a settlement agreement.
Okay,
but to your point,
okay.
I
apologize. I picked up the stipulation. I had in my hand the stipulation from April on the procedural part. So the settlement agreement will be marked for identification as hearing exhibit number 1 without objection and received into the evidence of this case.
Thank you.
Thank you. Mr. Elliott, I think you're up.
Madam Chair, we would call Steve Goldie to the stand.
Mr. Goldie, we're going to ask you to come down front where we can all see you. The court reporter can see you.
Recorder there. And the light is on. You have to sit very close to that microphone to be heard, I think.
Mr. Goldie, if you'll raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Goldie, would you please state and spell your last name for the record?
My name is Stephen R. Goldie, Goldie.
And what is your relationship to the applicant JACABB Utilities LLC?
I am the managing owner of JACABB Utilities LLC.
Thank you. And you're doing what every witness should do in looking at me when you to understand my question, but when you speak, you really need to speak into that microphone. It would help you. It would help the commission hear you also. All right, Mr. Goldie, would you please describe your educational and professional background?
Yes, I attained a BS degree in engineering from the University of South Carolina in 1977. After graduating in 1977, I worked as an assistant to the city engineer for the city of Charleston, South Carolina, dealing with streets and drains for approximately 6 months. Then I worked as an engineer in the engineering department of the city of Columbia, South Carolina, for approximately 4 years. In this capacity, I was involved with the design of water and sewer systems. I then worked for the Department of Health and Environmental Control as a permitting engineer in the Solid and Hazardous Waste Division. I left DHEC to start my own business. This was in 1983. The business is now Goldie and Associates Incorporated. This is a South Carolina corporation in good standing. I'm the president and its sole shareholder. My corporation provides a wide range of engineering services, and its principal office is located at 210 West North 2nd Street in Seneca, South Carolina. The range of services which we provide includes engineering, environmental compliance, laboratory services, and includes management of water and wastewater treatment facilities. We are also licensed to provide laboratory testing for both wastewater and drinking water. We also design wastewater treatment facilities and collection systems and obtain permits, including environmental permits for wastewater treatment facilities. I am actively involved as a consultant with numerous wastewater treatment systems in all aspects, including design, permitting, compliance with regulation, testing, and EPA requirements. We have a certified laboratory division and several licensed operators for North Carolina and South Carolina. In 2004, in response to calls from concerned regulators and prospective clients, I started JACABB Utilities LLC as a South Carolina public utility which owns and operates water and wastewater systems.
Excellent, thank you. Now, Mr. Goldie, did you prepare and cause to be pre-filed with this commission 6 pages of direct testimony?
Yes, I did.
Have you had a chance to read your testimony prior to your appearance here this morning?
Yes.
Do you have any changes or corrections to your direct testimony?
I don't believe so.
All right, sir. If I asked you those same questions here this morning, would your answers be the same?
Yes.
Very fine, thank you. Madam Chair, I would move Mr. Goldie's pre-filed direct testimony into the record as if given orally from the stand.
Mr. Goldie's pre-filed direct testimony will be received into the record as if given from the stand.
Thank you, ma'am. Now, Mr. Goldie, did you cause to be prepared and pre-filed with this commission 8 pages of rebuttal testimony?
Yes, I did.
Have you had a chance to review your rebuttal testimony prior to your appearance here this morning?
Yes, I did.
Do you have any changes or corrections to your rebuttal testimony?
No.
If I ask you those same questions today, would your answers be the same?
That's right.
Very fine, thank you. Madam Chair, I would move the pre-filed rebuttal testimony of Mr. Goldie into the record as if given orally from the stand.
Mr. Goldie's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Thank you, ma'am. Now, Mr. Goldie, drawing your attention to your rebuttal testimony, was there one exhibit, Exhibit A, attached to your rebuttal testimony?
Yes, sir.
Have you had a chance to review that exhibit prior to your appearance?
That's right.
Do you have any changes to that this morning?
No.
Thank you. Madam Chair, I'd move the Exhibit A to Mr. Goldie's rebuttal testimony into the record as if given into the record. This is the next hearing exhibit.
The Exhibit A attached to Mr. Goldie's pre-filed rebuttal testimony will be marked for identification as hearing exhibit number 2 and received into the evidence of this case.
Thank you, ma'am. Mr. Goldie, have you prepared a summary of your direct and rebuttal testimony?
Yes, I have.
Would you please present that at this time?
Yes. Madam Chair, Commissioners, in addition to my ownership of JACABB, I own Goldie & Associates, an engineering firm. Goldie & Associates have been providing utility service to public and private utility systems in the upstate area of South Carolina and western North Carolina for many years prior to forming JACABB. We were approached by DHEC and encouraged by ORS to become certified as a public utility to help failed and struggling wastewater systems and water systems to become compliant with DHEC and ORS regulation. I was really informed by DHEC representatives that they prefer permitting private and public wastewater utilities over permitting developers or homeowners associations to operate systems which they feel like neither of them are competent to operate these systems. Consequently, JACABB has sought and obtained approval from this commission to operate smaller wastewater systems such as the 30-lot subdivision at Keowee Springs. I believe that JACABB's wastewater services meet DHEC services standards as well as those of this commission. The sewer service territory for which expansion is sought is located in Pickens County. The proposed service territory will include 30 undeveloped lots and would consist of residential cottages in the Keowee Springs subdivision owned by Cliffs Keowee Springs Club. JACABB seeks approval of a sanitary sewer asset purchase agreement entered into between the applicant and the Cliffs Club Holdings, LLC, and it's dated July 7th, 2022. Performance of the agreement is conditioned upon approval of the application by this commission and approval by DHEC. If the development is built, the sewer system will consist of common force mains directing the sewage from the individual cottages to a common drain field. Individual septic tanks and effluent pumps will be required at each cottage and owned by the cottage owners. JACABB and the ORS have agreed on all issues and have entered into a settlement agreement filed with this commission. The settlement agreement is I believe is a reasonable compromise of firmly held positions which resolved all the issues in the docket. I would ask the commission to approve this settlement agreement. This completes my summary. I would like to thank the commission for hearing this case this morning.
Thank you, Mr. Goldie. Please answer any questions members of the commission may have for you.
Under the settlement agreement, I believe that Officer Regulatory Staff has waived cross-examination. Is that correct?
Yes, ma'am.
Thank you. Commissioners, questions for the witness? Commissioner Thomas?
Thank you. Good morning. Let me just ask a high-level question, just in terms of overall how the system works. I mean, I'm familiar with septic tanks and drain fields But what I'm familiar with is just not usually using pumps and not a community type thing. Can you just describe in a little bit more detail how that would work and how it's different from plain old single family residence that just has a septic tank and a drain field?
Right. Well, as you realize that drain fields are very sensitive to solids buildup. So we need to protect those drain fields. And so what will happen here is that the individual septic tanks will intercept the solids, and then we would use a effluent pump to pump it toward a master drain field into a common force main. So it would all be pressurized to get to the drain field. And so we need to protect the drain field from excessive solids.
So it's more related to keeping the wastewater moving. That's not necessarily going to move the way it needs to if it's just a gravity system. Is that?
Actually, it would be a force system, and then so it would not flow into the gravity. Yeah, it would not flow into a gravity pipe. It would be forced.
Okay. And so where does the water come from?
It would come from the individual cottages.
So they have, each one has its own well?
No, it would be it's a public water system.
Okay. So it would maybe be a county water system or something like that?
Yes, it's either Greenville County or it's escapes me right now, but it's a water district area.
Okay. All right. So in looking at the application, and I'm looking at Exhibit 4, and it's page 65 of, if you look at the number going down the side of the page, you happen to have one of those. If not, it's immediately before Exhibit number 5, so I'm looking at Exhibit 4.
I believe that's the construction permit from DHAC. Is that correct, Commissioner?
That is correct.
And it's near the very end of the application, I believe, the supplemental application.
Yeah, it's close to the end. Anyway, I'll just kind of mention to you what I'm looking at or thinking about there. So the what I'm looking at mentions the community, and it refers to 35 lots, and the supplemental application talks about 30 lots. Is there?
They originally intended to have 35 lots because the developer shifted his plan, and they wanted more property for a common area, and so it did get reduced to 30 lots.
Okay. So does that create any problem with the paperwork or permit or anything? It's just okay.
It was permitted by DHEC as a community system.
All right. All right, and then there is mention on that same page about the every 5 years the owners will provide DHEC a report on the pumping, the septic pumping. Is that something that how the owner's going to know they have to do that, I guess, is
the utility will send them a notice that it's time for them to get somebody to test their septic tank to make sure that it needs to be pumped.
Okay, and the utility being,
JACABB
JACABB.
Utilities will send a letter every 5 years to the individual.
okay. And, so who pays for that? Is that part of,
The homeowner would normally pay for that. We are not necessarily in the business of pumping septic tanks, but we have that capability, and if they could not find somebody to do that, but it's their responsibility to make sure that they convince us or tell the utility that they have inspected and there's not excessive solids.
all right. And there's been mention of clubhouses. This community have a clubhouse that's, related to the system that we're talking about here today, or?
The clubhouse would not be on this system. They have their own individual permitted system.
All right. Okay, thank you. That's all I had at this time.
Thank you.
Commissioner Caston?
Thank you, Madam Chair. Good morning, Mr. Goldie.
More.
Thank you for coming. To follow up on one of Commissioner Thomas's questions relative to the notification of the septic tank pumping, do you know if the owners or whoever purchases the lots will be informed or understand that every 5 years they're going to be required to pump their septic tanks?
Well, my understanding is that not necessarily will have to pump it, but they would have to verify that there's not excessive solids built up. But that's in the DHEC regulations.
So, and you probably just answered it, but I'm not sure. It registered with me. Will the owners or the folks that buy these lots, they're probably not going to be necessarily very familiar with DHEC regulations or anything. Will they understand, as far as you know, will they know that every 5 years you're going to have it inspected, pumped, or whatever? Do you know if
We normally put that in the letter explaining what the requirements are, and explain to them that they need to get it inspected and verify that there's no problem with their septic tank.
But you don't know if the developer himself, as part of, I guess, the information they provide to prospective buyers, will let folks know that before they buy. Not that.
Well, I think we had modified in the agreement as to what language we would use for that. But we have other systems in which it's required on the DHEC permit, and we notify the homeowners that they.
I think it was item 6 of the supplemental application. In essence, where it talked about the developer agrees to pay for funding, depreciation, renewal reimbursement account as required by the Pickens County Public Service Commission. Is this something the Pickens County Public Service Commission requires of any utility to basically fund or have some sort of depreciation account, or How does this work?
That they passed, the Pickens County passed a ordinance. I think it's been about 10 to 12 years ago, and it's never been used, my understanding. And this would be probably the first utility that is faced with that. And so we did verify with Pickens County that they will require an ESCO account. And so we talked to the developer, and they were in agreement that they would have to fund that particular account.
Well, I'm sorry. Will this be like a one-time fee or money that's put into this account?
My understanding is that, yes, it is a one-time fee in the beginning, and then it will be looked at every 5 years, and the county, using their own independent engineering, would determine whether there's additional funds required. But that would not be until after 5 years.
But initially, this would be funded by the developer and it would not be part of the rates. Is that correct?
That's the way we've worked it out, yes.
And at the end of that 5 years, if Pickens County Public Service Commission comes back and says, hey, it's not adequately funded, you need to fund more, what would occur then?
Then we would have to come back to the commission and reevaluate.
Has the system, the sewer system, has it been constructed yet? Is it completed or in process? Or?
It's in process. It's not completed.
Do you have an estimate as to when that would be completed?
Our first estimate was probably about 6 months ago, but things change. Construction demands and marketing issues that we're not in control of, but it's probably, I would venture that it would probably be about 50% complete at this point.
So, do you have an estimate, or is there an estimate of when the construction will be completed?
It will be in 24, I'm sure, but that does not guarantee that they will build the cottages.
Okay.
So, but I think DHEC gives them 2 years to complete the construction without redoing the construction permit.
But before the cottages or any cottage could be constructed, the sewer system has to be in place. Is that correct?
That's correct.
And the permit to operate won't or can't be issued until the construction's completed and signed off on, correct?
That's correct.
And you have a level of confidence it's going to be completed sometime in 2024?
That's what we understand from the developer.
Okay. So that could be anywhere from January 5th to December 31st, 2024.
Right. Yeah. I think they want to get it done.
I understand. I think that's it, Mr. Goldie. I do appreciate you coming. Thank you very much.
Thank you, sir.
Commissioner Carolee Williams?
Thank you, Chair Belser. Good to see you, Mr. Goldie.
Thank you.
My first question is, Jacob, why the spelling of your company's name?
I have to blame that on my wife.
Okay.
She took initials from our kids and their spouses, and that's what it made up. And we have a grandson named Jacob, but it's not spelled. It's spelled differently.
Well, I hope I will spell it now for my own use better, having learned the story of the name.
Yeah.
My first question It is really basic. The customer account charge, the $25, is that standard? Is it something you calculate? Is it standard for all of your customers?
Yeah, it's what's been approved previously by the commission.
Okay. And the late payment charge, when you look at the bill, I just wondered whether it made any sense to identify the $250 on the bill. I know that I would avoid a late payment more if I saw it. Is that just standard practice?
The $250 is not the late payment charge.
You're right. You're right. Thank you for the correction. The disconnection, it is on the bill is just saying in the event of disconnection, additional reconnection fees will be assessed. And I just wondered if there was any value in identifying that, or whether that's just a practice that makes sense in your business.
It's what we normally, that makes sense in our business.
To not identify the amount on the bill.
On the bill itself,
Right.
I'm not that familiar with the billing process because I have staff that does that.
Okay.
But we do notify them when we have to disconnect them that there would be a discharge, a reconnect fee.
I think I'm just noting from my own personal perspective, if I saw it, I'd avoid it even more carefully, knowing what the impact was going to be.
Sure.
It's just a personal note. And the sewer service availability charge, just for clarity, is once is that a monthly fee?
Yes, it is. The availability fee is what we require, because if they build one cottage out there, we cannot sustain the system with one customer.
Mm-hmm.
So the developers agreed to pay the availability fees until they transfer that responsibility over to the customer.
And so if somebody buys a lot but doesn't build, they will be responsible for paying that?
That's correct.
Okay. And you've had other conversations about the 5-year time frame for checking to see if effluent if the solids need to be pumped. Is that something that the developer, the realtor, is going to be versed in communicating so that someone's not surprised when they get the notice from JACABB 5 years later?
We'll try to do a good job in communicating to the new customer.
Okay.
That's
So
the case.
so you're not waiting until the end of that 5-year time frame. As they
Right.
become a new customer, you're letting them know.
That's correct.
Okay. Thank you for that clarification. No further questions.
Commissioners? Mr. Goldie, I have a couple. I'm over here.
Sure.
I know it's kind of hard finding us sometimes when we're talking. You had some questions about the pumping charge of the septic tank and maintaining the septic tanks. And you touched on this, but that was one of the terms of the settlement agreement addressed language regarding the pumping charge. Is that your understanding?
That's right.
Okay. And I think originally in the, was it in the sale agreement that the customer would be required to contract with the utility, JACABB? Does that sound familiar?
Yes. How that all started, if I may,
Yes, sir.
is that we downloaded from DHEC website the requirement that we enter into a homeowner's agreement. Well, it was an old requirement and it has changed at this point. And DHEC says that we don't longer require the utility to enter into such an agreement.
Okay.
So we're willing to take that out of the agreement.
And under the settlement agreement, the language has been modified that would allow the customer to either find a qualified inspection and pumping person, entity, or they could ask the utility to do it. Is that correct?
Yes.
Okay. And if they hire someone that is not the utility, because the utility is responsible for the system, has the authority to inspect and oversee the work that is done. Is that correct?
That's correct.
Okay. Because ultimately, you're going to be responsible for the system, not the third parties.
That's right.
Okay. But that does end up being a choice for the customer to make.
Yes.
Okay. I had a question about the availability charges too, but I think you answered that in response to Commissioner Williams's questions. How many systems is JACABB have now? Do you know?
Shoot, about 20.
Is that water and sewer?
Yes.
Okay. And when you say 20, are you counting sewer separate and water separate?
Well, some of the waters don't have sewer, and then
Right.
the very few have both. We'd rather have both in a development because it's easier to manage it, especially with turnoffs.
And where you are located, you're in Pickens County and Anderson?
We're in Oconee County,
Okay.
actually, in Pickens County, Greenville County, Anderson County, Lawrence County, and North Carolina. We have a couple of systems in North Carolina.
Well, I can't concern myself with those, but so, okay. I was just trying to get an idea. I knew that.
I'm sorry, in Abbeville County.
Who's over in Abbeville?
It's Great Water.
Okay.
It's a water system.
Okay.
It's on Lake Succession.
Oh, okay. Thank you. I know I've seen the name over the years and knew that you had a number of systems, but thank you very much. Appreciate your testimony today.
Sure.
Commissioner Carly Williams?
Thank you, Chair Belzer. Sorry to have one more question for you. I'm in the center here.
Oh, sorry.
You just, in Mr. Hunnell's exhibits, he attached some notice of violations, a list of violations. Would you talk some about those and the significance or the lack of significance of those?
Yes, certainly. I guess anybody who's been in this business knows it's never perfect. You don't have necessary control of everything that comes down that sewer pipe. And so we have to react to it, and sometimes it's not fast enough to be able to meet all compliance. But I feel like we do a good job keeping up with all the different systems. And but it's just unfortunate that sometimes, like a treatment plant may smell sometime. It may make some noise sometimes, but it's we try to keep up with all the testing requirements and the compliance issues.
Can you speak about how quickly you were able to resolve those, or it's not a world I know a thing about, and so when I see violations, it just causes some concern for me. I know it wasn't an issue particularly of the parties, but I'd just like to learn a little bit, understand it better.
Yeah. Every violation we immediately address and do whatever it takes to make sure it gets in compliance. And we notify DHEC of those corrective actions. And sometimes they do not fine us because they understand that, you know, these things are possible. And then sometimes it depends on the enforcement officer. Sometimes we go ahead and get a fine and we deal with it. So,
When you talk about taking corrective action, typically, how long does that take?
it depends on the issue. You know, we had one situation in which we understood that the one of the customers had a leak in their water piping, which we don't own the water, and it did a huge hydraulic loading on the small treatment plant and washed it out, and so we got a violation for that. Just things like that can happen.
Mm-hmm.
But we try to respond to it with the fact we have staff members that are on 24-hour emergency response to anything that may happen. And
So are most of these violations solved within, and there may not be an answer to this, but are most of them solved within a day, within a week, within a month?
some are within a day, some of them it takes a while to get corrected. It all depends on the type of issue it is. But most of them are dealt with immediately.
And immediately means,
I mean, that day.
okay, thank you very much. I have no further questions.
Right, sure.
Thank you, Commissioner Thomas.
Thank you. So this is going to be a flat bill rate for all of the customers. Going to have the same bill to pay, and you had mentioned that in some locations you have the water and the wastewater on both sides, but in this one you only have the wastewater. So to do a volumetric bill, do you ever do that when you only have the wastewater side?
I didn't understand. You said what kind of bill?
Based on the volume, the usage.
Oh, yeah, we have no way of measuring that. And therefore, that's why we request a flat rate. And it's based on DHEC's contributed loading regulations.
Okay. But I guess, do you have any systems where you do not provide the water, but you end up having the wastewater side of the, do you have any of those where you would charge based on the volume?
Yes, we have several of those. That's based on the volume, based on the approved rate for that particular gallon, $1 per gallon.
But if you don't have the water side of that, then how do you get the information that you need to bill the volume?
We don't bill, in that case, we do not bill by volume.
Okay.
It's a flat rate.
All right. Thank you. That's all I have.
Commissioner Caston.
Thank you, Madam Chair. Just to kind of follow up on that a little bit. And I've lost touch with all this stuff anyway.
Yes.
But relative to, I guess, the either per capita usage or however, whatever number you use, I think you said that is a DHEC number relative to usage. Is that correct?
Yes, they're common assignment. If you have a regular 3 and 4 bedroom house, they assign that should be 300 gallons per day consumption. And sometimes it's that, and sometimes it's less, and sometimes it's a lot more. Depends on who's occupying the resident.
And remind me, is that, I can't remember the standards. It was like a means number or whatever, but do you know, is that developed by DHEC from like 10 state standards, or remind me where that number comes from?
All right. They recently, well, I'd say in the last 5 years, they have revised their regulation, and they decreased the amount. It used to be 400 gallons per day per resident for a 3 and 4 bedroom house, and they have reduced that by 25%. And so under the new regulations, it's 300 gallons per day that they predict that resident will. Some of our systems we evaluate the typical flow, and sometimes it's more and sometimes it's less, but it's close.
Thank you. That answers that question. And are you required, I guess, the designer, are they required to use that number unless they can prove otherwise or come up with
Yes.
good information that it would be less?
We have the right to request if we have the appropriate information that they will accept, and say, you know, we got a transient community that most of the people aren't there during the week. They may be there during the weekends, and therefore we've kept records for the last 3 years, and their flow is a lot less than what DHEC had required us to use. And sometimes we have requested that, and DHEC has approved to use the lesser amount. But I don't recall any of them on JACABB facilities, but we have done that for municipalities and for other private systems.
Okay, so if there was historical data that, let's say, indicated the per capita usage water
Right.
was 80 gallons per day, would, and the sewage should be, I'm assuming, some percentage less than 80 gallons per day. If that historical data is available or can be shown, then would it be acceptable to use a number such as that instead of 300?
As long as DHEC approves it, yes.
Okay. And the rate, am I understanding that the rate is developed based on whatever that per capita per day usage was developed? Is the rate generally associated with, in other words, if the per capita usage is higher, say 300 gallons a day versus 100 gallons a day, would that affect the rate one way or the other?
And it depends on the type of system. In this particular case, it would not have an impact on the system, because it's whether you got 100 gallons a day or 80 gallons a day, you still have the same costs involved. But if it was a treatment system in which it's dependent on whether there's chemicals involved, that we have to use more chemicals for more flow or less chemicals, then there could be a difference slightly in the cost.
Okay, a leachate field versus a lagoon or aeration clarifier or such.
Right. Yeah,
Okay.
It's a static system, so it has to be there regardless.
Thank you. Sure you didn't go to Clemson Engineering School? Thank you, sir.
We're right next door to them.
Yeah, sure you are.
All my engineers are Clemson graduates.
Mr. Goldie, I started this because I just was interested in, I know that I've heard JACABB over the years, and I was just curious about the system. But those DHEC contributory loading guidelines, aren't those used for the design of the system?
That's correct.
Okay. So the system has to be designed in conformance with the DHEC contributory loading guidelines. And sometimes there may be variances that DHEC will grant on the design of the system. Is that correct?
Yes,
Okay.
that could be possible.
But when it comes time to designing the rates, are you looking at those contributory loading guidelines, or are you looking at the expenses, the operating expenses that are associated with the system?
Well, the design is impacted by the DHEC regulation contributory loadings because we have to have so many feet
Right.
of drain field because they want us to make sure we have the capacity for that design parameter.
But it's the fallout of the design. It's not that you're using those contributory loading guidelines to say, oh, a 3-bedroom house, we're going to have a rate of this for a 3-bedroom house and a rate of this for a 2-bedroom house. When the rates come into play, is it not the case that you're having to look at what you're having to put into the system, but also the expenses associated with operating the system?
It's basically the expense of operating
Okay.
the system.
Thank you, sir. Appreciate it. Any further questions for the witness? Commissioner Carolee Williams?
Thank you, Chair Belser. One final question.
Sure.
As this application evolved and as testimony evolved and we got to the settlement, the amount identified in the O&M cost for repairs became zero. How is that going to be managed? If you're able to tell me how that was arrived at, I'd like to know. Just thinking about, I know you're covered for a year based on the developer's warranty, so to speak. But for the remaining time frame, what happens if repairs are needed?
Well, that's why we were trying to estimate what it may be based on our experience that we have to typically support a system. And so we agreed that, yes, it can be removed because it's really a guess at this point. We have no hard facts to say we will have this many repairs. That's the risk of the business.
So if there are repairs, what happens?
We have to absorb those.
Okay. Thank you very much.
Sure.
Mr. Elliott, any redirect?
No redirect, Madam Chair, and that is the applicant's case. We'd ask that the settlement agreement be approved.
Thank you, Mr. Elliott. Mr. Goldie, thank you for being here today and for your testimony. I know we've covered a lot of ground, but appreciate you enlightening us on your operations. Thank you, sir.
You're welcome, and thank you.
And you may stand down. Thank you, sir. Mr. Mustian?
Madam Chair, if you're ready to proceed, I would call Ms. Dawn Hipp and Mr. Dan Hunnell.
Mr. Hunnell, Ms. Hipp, please come forward to be sworn. Does anybody need a break before we continue? Okay. Court reporter, if you'll swear the witnesses.
Ms. Hipp and Mr. Hunnell, you'll raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Hunnell, we'll start with you. Could you please state your name for the record?
My name is Daniel Patrick Hunnell II.
Okay. And by whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as Deputy Director of Water Operations.
And in connection with this proceeding, did you prepare or cause to be prepared 36 pages of pre-filed direct testimony?
Yes, I did.
Do you have any corrections, additions, or deletions to that testimony?
I do not.
Okay. If I were to ask you those same questions, would your answers be the same?
Yes, they would be.
Okay. Madam Chair, I would ask that Mr. Hunnell's direct testimony be entered into the record of this proceeding as if given orally from the stand.
Mr. Hunnell's testimony had confidential designation on 3 pages. Is that going to, how are we treating that?
We would, the company had designated that information as confidential. I gathered from the chair's prior ruling on that issue that it would be treated as confidential.
Okay, just want to make sure we're still on that.
Sure, yes, ma'am.
Mr. Hunnell's pre-filed direct testimony will be entered into the record as if given from the stand, and those portions that were designated as confidential will be maintained as confidential.
Thank you. And Mr. Hunnell, as part of your direct testimony, did you attach 2 exhibits labeled DPH 1 and 2?
Yes, I did.
Okay, and do you have any corrections, additions, or deletions to those exhibits?
I do not.
Madam Chair, and I can't recall as I'm sitting here if those were confidential or not, but we would ask that those be entered into the record as if at this time, as the next hearing exhibit.
I don't recall exhibits being confidential. Am I wrong on that? Does anybody?
I don't believe so.
I don't believe so. Mr. Hunnell's pre-filed exhibits that accompanied his direct pre-filed testimony and listed as Exhibit DPH1 and I believe DPH2 will be a composite exhibit marked for identification as hearing exhibit number 3 and received into the evidence of this case.
Mr. Hunnell, have you prepared a summary of your direct testimony?
Yes, I have.
Okay, can you provide that at this time, please?
Good morning, Madam Chair, members of the Commission. It's my pleasure to be here with you this morning. My direct testimony in this proceeding focused on ORS's review of the supplemental application of JACABB Utilities, LLC, which I will herein refer to as JACABB or the company, to establish a new service area and new rates and charges in certain portions of Pickens County, South Carolina, and for the approval of the Sewer System Asset Purchase Agreement between JACABB and Cliffs Club Holdings, LLC at Keowee Springs. Specifically, my direct testimony focused on a review of JACABB's application, a review of the Sewer System Asset Purchase Agreement, ORS's review of the proposed charges, including monthly sewer availability, and non-recurring charges, ORS's evaluation of JACABB's compliance with the South Carolina Department of Health and Environmental Control rules and regulations, and finally, ORS's recommendations in this case. ORS conducted its standard review and analysis of JACABB's supplemental application and the purchase agreement by issuing discovery with the intent to gather the information and documentation necessary for ORS to make an informed recommendation as to the reasonableness of the company's requests in this docket. This included reviewing the rationality of the company's requested rates and charges, proposed operating margin, and tariff changes. Subsequent to the filing of my direct testimony, ORS and JACABB reached a comprehensive settlement agreement which adopts all of ORS's recommendations and adjustments. ORS witness Don Hipp will explain the details of the comprehensive settlement. That concludes my summary.
Thank you, Mr. Hunnell. Ms. Hipp, we'll turn to you. Could you please state your name for the record?
Good morning. My name is Dawn Hipp.
Okay, and by whom are you employed and in what capacity?
I'm employed as a Chief Operating Officer with the Office of Regulatory Staff.
And in connection with this proceeding, did you prepare or cause to be prepared 15 pages of rebuttal testimony?
I did.
Do you have any corrections, additions, or deletions to that testimony?
I do not.
If I were to ask you those same questions, would your answers be the same?
Yes, they would.
Okay, Madam Chair, I would ask that Ms. Hipp's rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Hipp's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Ms. Hipp, as part of your testimony, did you attach one exhibit labeled DMH-1?
Yes, I did.
Okay, do you have any corrections, additions, or deletions to those exhibits?
No, I do not.
Madam Chair, I do believe, based on the chair's prior ruling, that that's been granted confidentiality. Would ask that exhibit DMH-1 be entered into the record as the next hearing exhibit.
Ms. Hipp's exhibit attached to her rebuttal testimony and marked as rebuttal exhibit DMH1 will be maintained as confidential, marked for identification as hearing exhibit number 4 and admitted into the evidence of this case.
Ms. Hipp, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Okay, and if you could provide that at this time, please.
Certainly. Good morning, Chair Belser and members of the Commission. My summary supports and explains the comprehensive settlement agreement reached between JACABB and ORS. The settlement agreement is a result of earnest good faith and complex negotiations, and within that settlement agreement, JACABB and ORS made compromises from their original positions to achieve a balanced resolution of all of the issues in this proceeding. ORS requests that the Commission approve the comprehensive settlement agreement as filed on January 3rd, 2024. For context, there were several areas of disagreement between JACABB and ORS, including the amount of legal and professional fees to appropriately be included in the monthly sewer usage and availability rates for customers of Keowee Springs. Another item was the approval of vendor contracts included in Exhibit DPH-1 that was attached to the testimony of ORS witness Hanel, and the ORS recommendations to ensure that the Commission has an opportunity to carefully review the agreements between JACABB and its unregulated affiliated business entities, to confirm the reasonableness of the scope of services to be provided, and to verify that the charges are consistent with current market conditions. And number 3, the resulting monthly rate for both wastewater usage and availability customers. The comprehensive settlement agreement settles the issues identified in the docket and is in the public interest, as the agreement requires JACABB to file all contracts with its third-party vendors or subcontractors, including those of affiliated business entities, with the Commission in a separate docket as required by Commission Regulation 103-541. Those must be filed within 30 days of the date of the Commission order. The settlement recognizes it is important for JACABB to demonstrate to the Commission that all contracts are reasonably equivalent to contracts that have been negotiated at arm's length or have been competitively bid, to ensure that JACABB and the company's captive customers receive services from the most qualified vendors at competitive market prices. As part of the settlement, JACABB agrees to allow customers several options to service the customer-owned interceptor tanks. In addition, the settlement acknowledges the ORS recommended adjustments to the estimated annual operations and maintenance costs, which, using the company's requested operating margin of 6.73%, result in a monthly rate for water usage and availability customers of $26.64 for the Keowee Springs service territory. And finally, the comprehensive settlement agreement saves the time and cost of a fully litigated hearing before this Commission. This concludes my summary.
Ms. Hipp, just one clarifying thing. When you were discussing the monthly rate, I believe you said water usage. Did you mean wastewater usage?
I did. Wastewater usage. Thank you.
Madam Chair, witnesses are available for questions.
Thank you, Mr. Mustin. And Mr. Elliott, under the settlement agreement, I believe you've waived cross-examination. Is that correct?
That's correct, Madam
Thank
Chair.
you. Commissioners, questions for this panel of witnesses? Commissioner Caston?
Thank you, Madam Chair, and good morning.
Good morning.
Good morning.
I guess just to kind of make sure I got everything clear here, relative to the pre-file cerebral testimony, did the company provide the invoice of $1,320 from Kirk McNessick to ORS for review and verification?
Yes, we received the invoice from the, I believe it was the accounting CPA, Mr. Mezek, for review. We understand that even though the invoice was for a higher dollar amount, the company was only seeking $1,320. We determined that that was duplicative of the accounting fees that are already included in the proposed rate calculation. So we removed those, and the company has accepted that recommendation in the comprehensive settlement agreement.
Okay, thank you. In the settlement agreement, I think it's Section B, paragraph 6(e)(7), provides for recovery of $6,531.25 legal and professional fees amortized over 3 years. Is that correct?
That is correct.
All right, so consistent with that, your pre-filed Cerebral testimony, that number excludes legal fees associated with the motion to compel. Is that correct?
It does not include legal fees related to the motion to compel, nor does it include legal fees related to the initial application filed by the company in this docket. ORS removed both of those sets of legal and professional fees from the legal invoices that we were provided in order to protect customers from what we considered to be duplicative costs. The company has agreed to that in the settlement agreement, and so none of those fees are included in the amount to be recovered through the rate of $26.64.
Okay. Has ORS made that recommendation in the past in other hearings that you recall?
We have made recommendations to exclude legal fees in other cases, electric, natural gas, water, and wastewater, where we found the fees to be unreasonable or duplicative or could not be verified.
Okay, and I guess to make sure I've kind of got a grip on it, you refer to page 12, I think, in your rebuttal, lines 19 through 20. When I read that, to clarify, the disallowance was because of the discovery dispute, not because of the need for additional discovery. Is that a fair assessment of that portion of your rebuttal?
I think that's a fair assessment. The disallowance is related to the company's incurred costs to litigate the motion to compel in front of the commission related to the discovery dispute between ORS and the company. So it's discrete to the litigation related to the motion to compel, which the company was ultimately ordered by the commission to provide that discovery to ORS. It is not a removal of the actual legal expenses related to providing the discovery to ORS. So that is included for recovery in the remaining balance of that invoice.
Okay, thank you, Ms. Hill. And Mr. Hunnell, I actually had a bunch of questions that I'd kind of formulated over the last few days, but they've pretty much been answered. And I appreciate you coming. I appreciate both of you coming. Thank you very much.
Thank you.
Thank you.
Commissioner Justin Williams.
Thank you, Madam Chair. Ms. Hipp, Ms. Hunnell, thank you for being here today. Ms. Hipp, I have a question about, I don't know if it's proper to say ORS's philosophy on legal fees or maybe your philosophy on legal fees. Would you or would ORS take the position that the legal fees for the motion to compel should be included if the commission ruled in favor of the company?
It's a very good hypothetical question related to the outcome. In this case in particular, our position is that it's unreasonable for customers to pay for the legal expenses related to the discovery dispute to argue in front of the commission when the company was ultimately required to provide that information to ORS. We feel that companies, of course, discovery disputes occur all the time. There's an informal way to remedy those between the agency and the company, which is usually very successful. We're looking for transparency and cooperation from the company, and it's our position that customers should not pay for discovery disputes in the manner in which we see in this case.
Thank you for that answer. And so it seems based on my interpretation of your answer, that ORS's position is that the motion to compel the litigation costs and appearing before the hearing for that particular issue in this particular case was unnecessary as proven by the ruling of the commission.
I don't know that ORS would say that it was unnecessary. We prefer to resolve discovery disputes informally, and we're very fortunate that we can do that with most utilities. In this case, we were unable to do so. The information that we requested was such information that we felt was necessary to allow us to make a determination and present our statutory responsibilities to the commission through our testimony. In terms of the company being able to argue related to a motion to compel, we feel that those fees were unnecessary to begin. That process was unnecessary.
And I think that what I'm looking for is the because they could have turned it over during the discovery process without disputing or causing the motion hearing to occur in the first place.
That is correct.
Okay. Okay. So you don't think that approach would put, if you can agree, I think agreement is great. Collaboration, cooperation, it's an awesome way to resolve matters outside of the hearing room. The only concern I would have is whether or not there's a chilling effect on parties, no matter who they may be, on availing themselves to the commission to resolve a dispute if they just genuinely have a different position than your office. Is there any concern by you or ORS for that?
Not in this manner, because we reached a comprehensive settlement agreement and the company ultimately agreed to ORS's recommended adjustment for legal and professional fees. So it's a discrete settlement agreement. ORS raised the concern to the commission. We felt strongly about it. You see it in our Sir rebuttal testimony that those should be disallowed. Ultimately, it will be the commission's decision, should this ever be litigated in future cases, to make that determination.
Okay. And I think you made your point very clearly, but just to put a exclamation mark behind it, this position that you're taking here is limited to this case and this case alone based on the facts and circumstances.
That is correct.
Okay. Thank you, ma'am. Thank you, Madam Chair.
Thank you, Commissioner. Any further questions? Mr. Mustian, any redirect?
No redirect.
Thank you. Anything,
Nothing.
Ms. Hipp, Mr. Hunnell, okay. I think I've been pronouncing it wrong, and I apologize if I have.
She has for 4 years.
Okay. I think that's what threw me.
And I miss Supervisor.
I thought I had the utilities name correct, and then after listening to the panel, I'm not sure I am saying it right either. So, Mr. Hunnell, Ms. Hipp, thank you for your testimony today. You may stand down. Thank you.
Thank you.
Madam Chair, other than just a general objection that Mr. Hunnell got off scot-free, we have nothing further.
Thank you, Mr. Mustian. I believe council, is there anything further with regard to the hearing other than the date for the proposed orders? And I believe y'all discussed that with our advisor this morning. Is that correct? Correct. Anything further? Hearing none, I'd like to thank the parties, the witnesses, and the attorneys for your participation this morning. Participation might not be the right word because it may not have been voluntary, but thank you very much and appreciate your presentations today. We'll take this matter under advisement and notify you with our decision at an upcoming business meeting. So,
Thank you, ma'am.
thank you very much. Everyone have a good day, and it's Happy New Year for everyone.
Thank
So
you very
Happy New
much.
Year. Thank you very much. We're adjourned.